I'm a federal administrative law judge with the United States Department of the Interior, and my subject today, appropriately enough, is administrative law. I think we should start with a brief examination of what is administrative law. And generally speaking, administrative law is that corpus of federal and state statutory and regulatory law which is typically administered by state and federal executive branch agencies and cabinet departments. Such entities are often referred to as regulatory agencies, and organizationally and constitutionally, such agencies are distinguished from the judicial branches of government, that is, from federal and state courts, which of course are a part of the judicial as distinguished from the executive branches of government. Now, because I'm an administrative law judge with the federal government, my presentation today will be primarily devoted to federal as distinguished from state administrative law issues and topics. I serve with the Office of Hearings and Appeals in the United States Department of the Interior, which department administers a broad range of federal statutes and regulations covering publicly owned lands in the western United States. For example, almost 90% of the state of Nevada is owned by the federal government, and of that large amount of public land, the Department of the Interior administers and regulates the majority thereof through a variety of subordinate bureaus and agencies, such as the Bureau of Land Management, the Bureau of Reclamation, the Bureau of Indian Affairs, and the Fish and Wildlife Service. Each of the aforementioned bureaus located within the Department of the Interior administers and regulates large tracts of publicly owned lands in the western United States under a broad range of enabling statutes and implementing regulations, including, for example, the Federal Land Policy and Management Act, the Taylor Grazing Act, the Mining Act, and the Federal Power Act. In exercising its regulatory authority under such statutes, the Department also administers a broad range of generic federal environmental statutes, such as the National Environmental Policy Act, NEPA, the Clean Water Act, the Clean Air Act, and the Endangered Species Act. The Department's implementation and administration of such regulatory programs under those enabling statutes constitutes an example of what is generically referred to as federal administrative law. And there is a broad range of other federal departments and agencies which perform analogous workplace and marketplace regulatory functions under a similarly broad range of other enabling statutes and implementing regulations. For example, the Department of Agriculture and the Environmental Protection Agency. The compendium of such statutes and regulations constitutes the overall corpus of federal administrative law, which also includes subsequent judicial review of agencies implementing regulations and agency adjudications by jurisdictional federal district courts and circuit courts of appeal. There is a large corpus of federal case law to which we also have recourse, especially with respect to issues of adjudicatory procedural due process under the auspices of the Administrative Procedure Act, the so-called APA. Such overall federal regulatory activity is focused and administered under the overall procedural umbrella of the APA, which was originally signed into law by President Truman way back in 1946. Since that time, the APA has been amended. However, its overall purposes remain the same, namely to regularize federal administrative procedures. The APA includes the following criteria and provisions. First, the APA requires agencies to keep the public currently informed of their organization, procedures, and rules. Second, the APA provides for public participation in the rulemaking process. Third, the APA provides uniform standards for the conduct of formal agency rulemaking and adjudicatory proceedings. Adjudicatory proceedings are those formal trial-type hearings that are required by statute to be made on the record after opportunity for an agency hearing. Such on-the-record hearings are typically presided over by administrative law judges such as myself. And finally, the APA prescribes the jurisdictional criteria for subsequent judicial review and appeal after agency action has been completed and after administrative remedies have been exhausted. Now, the APA is found at 5 United States Code, sections 551 through 559, 701 through 706, 1305, and 3105. Generally speaking, there are two major subdivisions. Sections 551 through 559 deal with agency procedures, and sections 701 through 706 deal with the criteria for judicial review following exhaustion of administrative remedies within a particular regulatory agency or cabinet department. Now, the Act imposes upon agencies certain procedural requirements for two modes of agency decision-making, namely general rulemaking to be published in the Federal Register, and in turn, case-specific adjudications which may conceptually and conveniently be thought of as administrative trials involving specific disputed regulatory compliance issues and specific parties. Again, these latter proceedings are typically presided over by an administrative law judge. Now, Section 553 of the APA sets forth the basic requirements for the first of those two modes of agency decision-making, and that is general rulemaking. Those requirements include notice of proposed rulemaking in the Federal Register, followed by an opportunity for public comment by interested persons. Generally, the public is afforded at least 30 days to comment upon department or agency proposed regulations. The jurisdictional agency then analyzes the public comments and follows this with the publication of final regulations in the Federal Register, which regulations are subsequently codified in the Code of Federal Regulations, the so-called CFR. The other major part of the APA process is the case and controversy adjudication mechanism, which implicates on-the-record trial-type hearings, which are presided over by an assigned ALJ. Sections 554, 556, and 557 of the Act apply to such formal adjudications, which are agency enforcement cases that are required by statute to be determined on the record after an opportunity for an agency hearing. Such formal on-the-record hearings include a specific right of cross-examination and a right to present testimonial and documentary evidence by all parties withstanding. Having now delineated the general outlines of the APA, I wish to provide you with a specific example of an adjudicatory program under which I'm currently conducting a hearing for the Office of Hearings and Appeals in the Department of the Interior. And this is just one example of a broad range of statutory and regulatory programs over which the Interior Office of Hearings and Appeals has jurisdiction to conduct such hearings. The program to which I have reference is a brand new one, recently created under the 2005 Energy Policy Act, which provides a specific example of the formal adjudicatory procedures that I have briefly just discussed. Under Section 241A of the Energy Policy Act of 2005, which is Public Law 109-58, which the President signed into law on August 8, 2005, Sections 4E and 18 of the Federal Power Act, which appear at 16 U.S.C. Section 797E and Section 811, were amended to provide for a new adjudicatory program and procedure for hydroelectric license applicants. And I'll quote from the statute. The license applicant and any party to the proceeding shall be entitled to a determination on the record after opportunity for an agency trial type hearing of no more than 90 days on any disputed issues of material fact. Further, under the new statute, the jurisdictional secretaries of Interior, Commerce, and Agriculture are mandated to, quote, establish jointly by rule the procedures for such expedited trial type hearings, including the opportunity to undertake discovery and cross-examine witnesses. The referenced jurisdictional departments published their new implementing regulations on November 17, 2005, and those appear at 69,804 Federal Register, Volume 70, number 221, Thursday, November 17, 2005. The Interior regulations will ultimately be published in the Code of Federal Regulations at 43 CFR Part 45. Therein, all of the procedural rules for conducting these new hearings are set out, including procedures for pre-hearing discovery and related motion pleading, procedures for conducting pre-hearing conferences, procedures for conducting the hearing itself, and the timelines and procedures for filing of post-hearing briefs, proposed findings, and for the issuance of a final decision by the presiding administrative law judge. And what this example provides for you then is an example of both general rulemaking, the publication of these rules in the Federal Register, and specific adjudication under the general rule of the APA. It so happens that I am currently conducting the very first adjudicatory trial under that new statutory provision for the three reference departments, Interior, Commerce, and Agriculture. Well, I hope that you'll have an opportunity to review those new regulations. It's an exciting new program. Relatedly, I hope that this general overview of administrative law has proven helpful to you. For those of you who ultimately elect to practice in this overall area of law, as I have done for many years, I think you find it both interesting and professionally rewarding. And in that context, I would point out that there are many opportunities for postgraduate academic specialization in this area. Most law schools offer LLM degrees, Master of Laws degrees with a specialization in administrative law. I received an LLM many years ago from the George Washington Law School in Washington, D.C. I practiced law there privately for 25 years, and I used that degree extensively in that practice, and now as a federal administrative law judge, it's paying additional dividends. So for those of you that are interested in this area and think you might want to go on for a master's degree, I would encourage you to consider it very seriously. It's a very useful area of specialization. With that, I'd like to thank you for your attention. I hope the presentation has proven generally useful, and thank you very much.